Hello, my name is Brian Hill. I'm here today with Carol Ponton. We are the two senior attorneys at Hill and Ponton, and Matt is not available this week, so we told him we'd fill in for him. So what we'd like to do is Carol has some real concerns about veterans making a serious error in their cases, and I'm going to let her talk about that.
Well, I think one of the number one areas where I see veterans losing benefits is under what we would call service-connected complications or secondary service connection. So let me first say what a complication is. So say you have diabetes that's service-connected. Diabetes causes a lot of problems like peripheral neuropathy, erectile dysfunction. It could cause chronic renal failure. There are lots of things that causes, and if it does, then that's considered a complication and is service connected. So you don't have to file a separate claim, but what you have to do is make sure the VA is aware of these problems. So I want to read just the list that I have for diabetes, the list and it's not complete, but it shows you how many complications there are from diabetes. And I do not see my veterans getting these. I don't see them letting the VA know. The VA is not going to act on something unless you beat them over the head with it sometimes. You really need to bring it to their attention. So for instance, we talked about chronic renal failure, and sometimes my veterans don't even know they have that. And the way you find out is you look by your blood labs. And if your creatinine is elevated, then you likely have chronic renal failure. And that is a 60% rating usually right there. But what I'm saying is the VA is not going to point that out to you. And a lot of times these VA doctors and regular doctors are not pointing it out to my clients. So you need to look at your labs and see if your creatinine is elevated. Peripheral neuropathy is when you have numbness, tingling, loss of feeling in your hands, your arms, your feet, your legs. If you have that, that's definitely a complication of diabetes. And that can lead to inability to walk, all sorts of things. So you need to make sure if you have that, the VA knows. Diabetic retinopathy, cataracts, all sorts of problems with your eyes. Heart disease is a big issue, a big complication of diabetes. So whether it's AFib, your heart's not in rhythm, or whether you have coronary artery disease, that's a complication that you should be getting paid for. If you have a stroke, that can come from the diabetes. If you have hypertension, that can be caused by diabetes. Another thing that veterans don't think of is dementia or depression. The medical treaties, the studies show that a person who has diabetes is far more likely to have dementia or depression or mild cognitive disorder because they have diabetes. That alone could cause it. So you need to make sure if you have any of these problems that you're letting the VA know. Now, let me give you another more complicated complication. Say you have diabetes and you have peripheral neuropathy, so you've lost the feeling in your feet, and then you trip and you break your shoulder. That shoulder should be service-connected because it was caused by a complication of a service-connected problem.
So I think one of the things that's important to understand here is this issue of, do you have to file a claim for this complication? Now, I think if you asked us whether or not to do it, we're going to tell you to do it. But if you have filed a claim in the past like this, and say you're at the Board of Veterans' Appeals with your case, what the law is that the VA has to consider not only the written claim that you made, but any complications or secondary conditions related to that claim without the filing of the claim. And the reason that's important is because it's important for your effective date. So assume that you had, as Carol said, diabetes, chronic kidney disease, and you got to the board, and it's 5 years later. Then there's a good argument that if they had notice of that chronic kidney disease, then they should have considered it in your claim, and your rating and your effective date of your rating should go all the way back to when you filed the claim for diabetes. So this is a very, very important thing for you to be aware of, and to make sure that when your medical records, especially if they're private medical records, that they're talking about that. And it's always best to have the doctor include in there, and this chronic kidney disease is related to his diabetes.
So they would be put on notice by either you having filed a separate claim for that, or, as Brian says, it's in the medical records. This veteran is suffering from chronic kidney disease because of his diabetes. Okay, the second, it's kind of complicated because one is considered a complication. It's something that automatically happens in many cases due to this disease, and other is a secondary service connected. And I want to give you this as an example: PTSD or a mental problem. Okay, if you have a mental problem, the studies that they have done show that you're far more likely than not you're far more likely than other people to get headaches, sleep apnea, erectile dysfunction, AFib, another one of your heart is irregular, regular heart disease. By the way, women who have PTSD have a 5 times greater chance of getting heart disease, and that study just came out. You could also have dementia or GERD, the gastrointestinal problems. So when people have any mental problem that's service connected, and they have any of these other problems, they should file for secondary service connection. And you do have to file a claim for these.
There's one issue that I think you should be aware of. There's sometimes that the veterans will come to us and they'll be angry that their doctor has said in their medical records that they're obese. Doctor's definition of obese is different from most people. Right. But if that's in there, then there's a theory in veterans law that you can use the obesity to service connect other things. Obesity by itself, the VA is very clear, is not a service connectable condition. But what the regulations and the case law is saying now is that if you have obesity and then you develop hypertension, if you have obesity and then you develop diabetes, you can use and you relate the obesity to, say, for instance, you have a horrible back condition and you can't get out and exercise, and as a result you've gained weight, and then you get diabetes. The case law now allows us to use that obesity as a bridge between the back and the hypertension or the diabetes. So if the doctor's writing obesity in your chart, that's not all bad. Nobody likes to have that in their chart, but if it's there, it's not all bad.
Well, all right, and so in continuing on these secondary service connections, they're endless. So let's just take sleep apnea. Say you have sleep apnea. People who have sleep apnea are more likely than others to get cardiovascular disease problems, heart failure, arrhythmia, seizures, COPD, that's chronic obstructive pulmonary disease, pulmonary hypertension, depression, hypertension, or headaches. So sleep apnea, if you're service connected for sleep apnea and you have any of these conditions, you should be filing for a secondary service connected for this. And it's not just these few that I've pulled out. So for instance, I have hypertension. If you're service connected for hypertension, you are more likely than not to get chronic kidney disease, maybe have a stroke, headaches, diabetes, and edema. And so you should be filing for any of these secondary claims if you have them. Now, this is just a short list. So you can imagine how many benefits veterans are losing by not figuring out what diseases they have, what are they service connected for, and is there a connection between the ones that are service connected and the ones that are not. So this is something you can Google. Google is great about bringing up a lot of these medical studies that show you that there's a relationship between certain diseases.
I'd just like to comment on hypertension. When I talk to my vets about hypertension,
which is high blood pressure,
I tell them that hypertension is a gateway rating, and by that I mean I say that the most you're likely to get before your hypertension goes really bad is a 10% rating, and most of the time it's a 0% rating. Right. But it's a great rating to get, because once you have that rating, then the heart can be connected. It's just amazing the different things that you can argue are connected. Because
unfortunately, hypertension causes a lot of these problems, which is the relationship.
And Carol's suggestion that you go on the internet is good. That's a lot of times we go there looking for medical literature so that we can send our experts the medical literature that we find, then they can add to it what they have from their professional knowledge. But you have to be careful. You have to be careful that just because there's some medical literature out there, that doesn't mean that it's always the case. So that's one of the things that working with a lawyer can help you. And they can tell you, I see that there's some literature out there, but in your case, I'm not seeing the factors that tie it up. You don't want to get involved in unnecessary litigation with the VA, because that's when things can go haywire for you.
And what he's saying is, say that your chronic kidney disease started in 1980, but your diabetes didn't start until 2010. It's unlikely that the diabetes could have caused the chronic kidney condition in that situation. So you need to be thinking about what started first. Did the complications or the secondary service-connected problem come on after that disease? There are lots of things to think about. But there's lots of ways to get more benefits than normally a lot of veterans are thinking.
Okay. Are we done with that issue?
We're done with that issue. We're ready to take questions.
Okay. Let me just run up here real quickly and get back to the top. Boy, there's a lot of questions here. Let me just address this question. I am a Vietnam vet diagnosed with bladder cancer 2010, second to Agent Orange, and treated 8 years before major surgery. Refiled when bladder cancer was approved. Can I get my VA comp from 2010 or just after it was approved? The answer to that is this.
The answer is very complicated.
If you have a presumed condition, your presumed condition has an effective date that bladder cancer was accepted. But for a long time before bladder cancer was accepted by the VA as a presumed condition, we had good experts who would relate bladder cancer to Agent Orange exposure, and in that case, we were not relying on a presumption. We were relying on what's called direct proof, direct evidence, a direct link. And so, if you've got a doctor who's saying that regardless of the presumption, I'm telling you that his 2007 bladder cancer was related to Agent Orange, that's the nexus that you need for direct connection. And in that case, you could get benefits back to when the first diagnosis occurred.
But this depends on, when did you first file? When you filed, was evidence of bladder cancer in the record? There are a lot of questions that need to be answered in order for you to know exactly how far back you can go. Because remember, if it's an Agent Orange, if you're in Vietnam and it's an Agent Orange accepted case, they've accepted that as service connected, and you have filed a claim for anything, and it shows in the record that you also happen to have bladder cancer, even though you didn't file for it, then that's a claim for bladder cancer. Okay?
All right. So here's another one, Carol. I'm going to let you take this one. Is it possible to win secondary headaches claim? This came from Ashley. Is it possible to win secondary headache claim with a headache log and a medical side effects list only? I read that the diagnosis is not required for headaches and migraine claims.
I'm really not exactly sure what you're saying.
I'm not either.
Because secondary to what? Because if you had headaches in the service, then that's a direct claim. That's something that you had. And you would prove that I would prove that by, first of all, looking in the service medical records. Did they say you had a headache? If it didn't, then you want to get a statement from someone who knew you before and after service, who said you didn't have headaches before service, but you sure did right after, and they have continued. And you would want a statement from yourself saying that as well. The diary, unless it was kept during service, would only be helpful to show how bad the headaches are right now. But if you happen to had a diary during service that talked about your headaches, I would definitely submit that. But then I think you're going to need someone that diagnoses you with headaches and says why they're service connected. It's either going to have to be a VA doctor, or you have to go to get your own doctor saying they've read your records and they feel it's as likely as not that this is related. Now, if you're talking secondary, then maybe any of these diseases that I talked about that you're service connected for could have caused or be causing your headaches.
And remember, this is one thing that I continually talk with my staff about. When you get that doctor writing the opinion that it's related, tell him when it started.
Exactly.
So you'll know when your effective date is. Okay, so now we have one from David that's a two-part, a little complicated, but let me just read it. Went to my C&P and one claim the DBQ for sinusitis, rhinitis, and other conditions of the nose to include the throat, my evaluator became confused, and C&P examiner was confused. That's unusual. Became confused and needed the esophageus DBQ. And then David continues down here. Any possibility the VA will acknowledge we had the correct DBQ since I had a sinus diagnosis? You want to take that one, Carol?
Again, I'm not quite sure. When they did the DBQ, did the examiner say you had sinusitis and that it was service connected? It seems to me that all of the DBQs that are turned in should be considered by the VA. And if you feel that you were not evaluated for sinusitis, then you should send a letter to the VA saying, my claim is for this. And I feel that when the examination, my examiner was confused, and when they did the evaluation, I don't think they addressed what I'm claiming.
One of the things that I deal with day in and day out is my veterans coming to me and saying, we're good. My C&P examiner told me he's gonna nail this for me. And I tell him, my experience is he was blowing in your ear. It just doesn't happen. So, we, the two of us, don't rely on the C&P examiners too much. We get outside opinions. We either get the treating doctors or an outside doctor to put it in writing. If it's not in writing, it's not there.
And also, I'm not sure, have you had a chance to look at the DBQs? Because just like Brian said, sometimes what the doctor tells you is not exactly what ends up in the DBQ. So you really need to see what the doctor said before you complain. And you have a right to that. It should be, we have our own online access. So I'm never quite sure when you have access to the VA, whether you're getting those forms or not. But if you don't, then you should write them a letter and ask for a copy of them, and they will send them to you.
Okay, here's one, Carol, that I think we see a lot. My DBQ was denied at the HLR level in 2021 because it was done via telehealth by a doctor not licensed in the state where I reside. Should I send it to the board, or is it a waste of time? Boy, this is a tremendous question, because it deals with one of the biggest problems that we have, and that is the VA's move to only accept what their doctors are saying about your condition. They and I think they still are refusing to accept opinions from our experts, where our experts are doing the examination by video telehealth, whereas they do that with their doctors and they have no problems with it. My advice to you is the fact that the doctor's not licensed in your state is irrelevant.
Exactly.
The doctor's given a medical opinion that he's qualified to give. I would definitely file that with the board and get someone to write an argument for you, just raising hell about what this rating decision said.
Because even though the regional office, where you first file your claim and where you can file a higher level review, even though they are not accepting this, the board is. The board is not paying any attention to the VA rule saying it has to be done in person if it's not a VA examiner.
Okay, Jody says, are the universal joints of the ankles connected to the legs, then connected to the hips and the back for range of motion? I don't think either one of us are qualified to answer that question.
I'm not quite sure, but could that be the secondary service connection you're asking about too? A person has an ankle problem, and therefore it causes them to have their gait is off, so they have a problem with their knees, their hips, or their back. Is that what you're asking? Because if it is, that's another example of a secondary service connected problem that you need to file specifically for, because it could affect all of those areas. But if it's another question, you're going to have to be a little, if you can write us again, or we'll check that out.
And just for your information, my experience in the medicine, and which is something I've been doing now for 30 years, working in litigation, it seems like the secondary conditions go down the spine and into the legs, but they don't generally come up. So,
I don't know, Brian. I've gotten a lot of benefits from people that have a gait that's off, whether it's because of their ankle or their knees.
That's true. Mm-hmm.
And it could affect your hip, all sorts of things.
Okay. Here's one from Brian. Good name. What's the best way to file the initial claim? Just a few, then go after the secondary: PTSD, tinnitus, depression, anxiety, fatigue, What do you think about that, Carol?
What's the best?
What's the best way? Do you file the initial claim and then file for the secondary, or do you file it all together?
Oh, you file it all together, because remember, you want to have the earliest effective date possible, because that's when you start getting paid. So if you have to clarify later on that I'm filing for PTSD and that's what's causing my headaches, that's fine. Okay. But file everything as soon as possible. That's always my advice.
Jody followed up about the DBQs, and I'm gonna talk about her second question too, because she says she had the out-of-state issue, but they were done in person. If they're done in person, and again, what are we talking about? Obviously, if it's an orthopedic exam, it almost has to be done in person. But if it's a mental exam, we equate a video telehealth examination as the same as in person. But I can tell you that if it's not in person and it's a mental exam, that's a problem. That's a real problem.
Only for the regional office, not for the board.
No, it's but even at the board, it's there's the weight.
That's the weight, but it's not.
Evidence.
It's still considered as evidence, where the regional office just ignores it like it didn't appear.
Okay, here's one for you, Carol. It's from Miss K. Can I file the chronic pain secondary to migraines?
Chronic pain secondary. I don't.
Yeah, you can, because just in the past couple of years, the VA has recognized that chronic pain. Well, let me start here.
Yeah.
Migraines are limited to a 50% rating. And you have to show significant episodes of a migraine pain, and you have to show that there's a significant effect on your ability to earn a living. But you're limited to 50%. But if you can get a service connection for chronic pain, the rating can go up. Now, so just within the past couple of years, VA has recognized chronic pain, and they rate it under the mental rating. So what they consider chronic pain to be is a mental condition, and what that means to you is that if you're going to, when my vets ask me, can we do a chronic pain claim, I say, who's treating you, and who's giving you the diagnosis that you have pain secondary to this, and a lot of my vets are saying, I just have it. I'm not being treated. And I said, well, you need to be treated. You need to be treated, and you need to get a diagnosis, and then we'll talk about filing a claim for chronic pain.
I have not seen great ratings for chronic pain. That's the problem. And that's why, once again, you should go to, if you have a headache, maybe, and it causes depression. Remember, that can be a secondary service connection. This headache is causing me to be depressed, anxious, upset. And sometimes it's easier to get a higher rating for the mental than it is for the headaches. So even if you're service connected at 10% for headaches, you can get a 70% rating for depression.
Okay, here's a question from George. Can you work and get a claim for TDIU? If you filed a claim for TDIU while working and soon retire, are there any forms you need to resubmit to the VA notifying them that you are not working anymore? You want to take that one, Carol?
Well, technically you can't. TDIU means unemployability. You're not working. What that means is you could be working and you're earning under, say, $13,000 or $12,000 a year. But if you're working and making more than that, you can't get unemployability. Now, if you know you're going to retire because you have these service-connected problems, you can file a claim, but the effective date is only going to be when you actually stop working.
Just a little bit of a caveat to that. The VA does recognize marginal employment. And a lot of our experts, when we talk to them about, so if you're looking for TDIU, but you're not making below substantial gainful wages, which is considered the Social Security poverty line of about $12,000 or $13,000
Right.
now. Say you're making $18,000. Well, you're not under SGA. Then the question becomes: is your employment marginal? And because the VA, if your employment is considered marginal, the VA has to pay you TDIU benefits. That's a really tough claim to make, but it's there. And in certain situations, I have a case I'm working on right now where the man is a certified accountant. He's in his career, he's making $50,000, $60,000 a year, and now because of his service connected conditions, he's making 19. So when you compare what his normal wages are to what he has now, the argument is that's marginal employment. It's a hard argument,
It's very hard,
but it's there.
But that's another time when get these secondary in, because if you get 100%, then you don't have to worry about whether you're working or not. Okay. You're entitled to that money. And a lot of people with the problems they have, if they filed all these other claims, they would have 100%.
Okay, here's a question from Juan. When filing for a secondary claim, can it still be deemed as the first condition before separation?
I'm not sure.
Well, he wants to know whether the effective date for your secondary claim can go back to the RAD, the release from active duty date. And the answer to that is it depends. It depends on when the primary claim was service connected. If the primary claim was service connected in the first year after service, then yes. And
if you filed that claim for a secondary within the first year, then yes.
Well, even if he didn't file it in the second year, if there are ways to if the VA
if it's a complication, not a secondary.
Okay, so you got two lawyers disagreeing. Okay, here's one from Richard. I need to go in front of the benefits committee. Can you get me there?
I don't know who the benefits committee. Are you talking about for? I'm not sure what you mean by the benefits committee.
Yeah, I'm not either.
There is no, I don't know of a benefits.
No.
There's, you file a claim and it's through the benefits side of the VA, but there's no committee that I know of.
Okay. Juan, if you, Richard, if you want to try to shoot us back, let me just check down here to see if you did shoot us back. No, I don't see anything. Okay, Richard, so we don't understand your question. I'm sorry. Try again. All right, so who's next? Let's see. Wow, a lot of questions here. Holy mackerel.
Okay.
Let me figure out where we were. I know we did one. It looks like Kalo KTV. Can someone receive receive VA compensation with an other than honorable discharge? Okay, so here's how this works. An other than honorable discharge is not a bar to the receipt of VA benefits, but when the VA gets your claim and they look at your service file, they make an administrative decision as to whether or not your service is such that it allows the payment of these benefits. A general discharge, they don't do that. But when it's other than honorable, they'll look at it and they'll make a decision as to whether or not that bars you from getting VA benefits, and they'll issue an administrative decision. You should get that. If you get denied for that reason, you should darn sure ask the VA to send you a copy of the administrative decision. They don't do that. Because there may be something in there where they've got the facts screwed up, and a good example of that is that I have a vet who served in Iraq, had one period of honorable service, had the second period of service. He was in Iraq and had terrible combat experiences, and came back and took it out on his wife. The VA denied his claim based on the conduct in the second period of service, and they never considered whether or not those horrible combat experiences may have been what caused the domestic problems he had. And so here we are 10, 15 years later getting that administrative decision and saying, hey, look, this is not this, they didn't really consider the fact that there was a cause related to service for the domestic problems.
And you should always try to get these upgraded. I have seen so many that were filed years ago that were denied, and they've been upgrading a lot of them because they didn't consider what veterans went through back then. They just acted on whatever way they were just really hard. And I think that has changed substantially. I think the government realizes they made a mistake, and I think they're re-looking at a lot of these. But when you send in a request for upgrade, you need to give them the extenuating circumstances. I had horrible PTSD. What had happened to you? Give them a chance to understand what was going on, and you'd be surprised how many are being upgraded.
Okay, next one comes from Quincy. Can you get sleep apnea secondary to tinnitus? And some people say tinnitus. I say tinnitus. Not one. That's
I
not
am
one I've
not
heard.
sure. I haven't researched that yet, but that's a good question. I don't know offhand.
Okay. Okay. Let's see. Where are we now? We're here. David asked, sleep apnea is secondary to what?
Sleep apnea. Okay, so sleep apnea can either be caused by, which is secondary to PTSD or a mental problem, okay, or sleep apnea itself can cause other problems. Let me just get my list out here, like heart disease, seizures, chronic obstructive pulmonary disease, pulmonary hypertension, depression, bradycardia, hypertension, or headaches. So it can either be caused by something or it can cause other issues. So I wasn't quite sure, do you have one sleep apnea and it's causing other problems, or are you asking, can you get sleep apnea service connected by PTSD or depression? And the answer is yes. But if you want to make that a little clearer, I'll be glad to.
If I can find the next question, there's just a ton of questions here. Okay, so Paul asks, I got a glaucoma diagnosis, early 40s, no family history of on either side. Has anyone made a service connection for this ailment? You know, I can't answer that precise question, but I can tell you what we do. When we get your claim, when we take the case or the claim for a person, we get the claims file. And then we go through that claims file page by page, including your service record, and do a chronology of everything that's happened to you in service and after service. And then we have a conference with you, and then we start talking about, well, okay, he's got glaucoma. Did he have something in service? Did he have some, and we'll go to the books and study the books to see what they've got. I don't know the answer to your question offhand, but I can tell you that we take cases like this all the time, where we think that it's worth the time and effort to figure out if there's a connection here.
Yeah, there are lots of questions. Do you have diabetes? Do you have hypertension? Or do you have other things that could be causing this?
Okay, Robert asked, I did not file for my knees and my neck and my back on my initial claim. Army lost my medical records, so I only filed for my diabetes type 1 and PTSD. 90%, I was discharged for diabetes. I think that's it. And let me just see if Robert's got another question here. Was this one of those deals where you get 140 characters and that's it? I guess so, huh?
I don't know.
Robert, I'm not seeing the next question. So I don't really know what you're asking. I guess I'd ask you
I have opinion
to do it again. Okay, here's a question from AJ. Vet changed the plantar fasciitis rating criteria earlier this week. I'm already service connected for it. Can the VA now reevaluate under the new rule? You want to answer that? You want me to? Answer is yes. Yes. If they've liberalized the rating, they can. I saw one of these prior sessions where Matt was talking about that. If you've got a great rating under the old system, the last thing you want to do is file for a new rating, because then they'll apply the new, more, for instance, for your back, the new more strict rating diagnostic code. But if you've got a rating and you think you might get a higher rating under the new code, by all means, file for it. Okay, that was AJ. Here's Michael. Will the 8 pieces of legislation be passed for toxic exposure be passed, and in what form? God only knows.
We have no idea. There's so many, we watch all of that, and so many bills are introduced. So many things look like they're going through and they don't, or they go through and they change them substantially. So until something is passed and signed, we never know.
Okay, here's a question from James, and this is another one that just is a real issue for us. I won my appeals at the VBA, but my effective date was the date of my appeal, not the date I reopened. I also submitted a service record into the evidence not previously reviewed by the VA in denial, and I think you ran out of your 144 characters at that point too. But we can talk about this. This is a red letter issue for us, Carol.
All right. So they should go back to if you filed a service medical record that wasn't previously in the file, that reopens all earlier claims. So you should have an argument about going back to when you first filed for that. But remember, they're not going to do that for you. You have to let them know what your argument is. It's not just that you're entitled to an earlier effective date. Why are you entitled to an earlier effective date? And I would send in a copy of of the service medical record and point out that it was not in the file until you submitted it.
Okay, there's an addendum to that. When they passed the new, they started the new AMA system, the new appeal system. I swear, somebody up there said the way we're going to pay for this is not to pay effective dates. It used to be with the VA, when you filed a claim and you won the claim, you got an effective date on the date of the claim. Now you're getting an effective date on the date of the C&P examination every time. And this is a great example of what the VA is doing. Is they're messing with the veterans on the effective dates.
They know that they've been told by their VSOs and everybody, don't appeal this. You might lose what you have. You got 100% now, go with it. And they're losing years and years of benefits in many cases.
Yeah, that's your VA at work. Next is from George.
Which means you can appeal that, and you should appeal that. Yeah. I'm not saying it's lost. I'm saying if you don't appeal, you've lost it, but you shouldn't lose it.
Here's a question from George. I suffered a back injury while in the service and went to sick call and was told that I had a pre-existing condition. No pre-existing condition was found on my entry exam, and the VA acknowledged this. Gosh, we're just not getting the questions here. We're just getting statements. But this isn't a presumption of soundness question,
right?
And once you get through that entry examination with it being noted as a condition that will affect your service, you have gained the presumption of soundness. And I don't care whether you had a pre-existing back after that or not.
They have to prove it.
They have to prove it.
They being the VA.
The burden has to prove two things. They have to prove by clear and unmistakable evidence that the condition existed prior to service. And then if they prove that, then they've got to prove by clear and unmistakable evidence that the condition was not aggravated by service. Horrible, very, very difficult burden.
A difficult burden, but unfortunately, the VA doesn't seem to recognize that in their decisions. So if possible, I always have statements from family members and people who knew you. You had no problem prior to service, but you developed one in the service. I think that's really important because it raises the issue, and then it shows the VA has no proof whatsoever. Unfortunately, a lot of times they just don't follow the law.
Yeah, and this is an area of the law that has got some absolutely huge payoffs.
Yes, huge.
The VA prior to 1994, I think it was, took the position that they didn't have to show these things by clear and unmistakable evidence. The court and the general counsel came out with opinions saying, no, that you're wrong. All of these cases where you've decided based on simply the fact that you decided that it pre-existed are wrongly decided, and they have to be reopened back to the date of that claim. Now, that's clear. That's clear prior to the 90s, whenever that happened. But even after the 90s, nobody got the message to the regional offices, and they continued to do it. So if you had a denial for existed prior to service in the past, you really need to talk to somebody about that.
That's a great claim, and you've got great benefits going all the way back. But remember, you got two things. You got to show that it's service connect. You've got to prove and get the service connection, and then you've got to get the rating. The VA has lots of ways of denying you. One is they don't give you the service connection, and then you fight and get it, and then you get a 0. So you also want to be either having people talk about how bad your back problem was, or medical records if you have. Sometimes you're able to find a chiropractor that you went to years ago, and they may not have records, but they may remember you because of how bad it was. So remember, you got two things you're fighting for.
Okay. Dwayne says WebMD is a great resource, and you're right. It is. I would encourage you to use it. Angel asks, why is my claim taking so long? 2 years. Carol, don't get mad.
I can't talk. There's some great people at the VA, and I agree that there's some people I just love over there, but then there's some other people who are not so great. But one of the problems with the VA is they take forever. Another area where I found a real problem, and this is when people, now it's not under the new system as much as it was under the old system, where you say you went to the board and you filed a VA-9. A lot of times either you didn't ask for a hearing, but they noted you did, and therefore your case is sitting there waiting for a hearing, or you asked for a hearing and that's what you're waiting for, is for them to get the hearings. Now, on the good part of that, if this is what's holding it up, there was just the other day a directive saying all hearings for these cases will be set immediately. So I got 5 notices today And none of those veterans really had asked for a hearing. So that just gives you an example of how messed up their system is. So I would file a letter to the VA or the board. I don't know where your case is. If your case is at the VA, you should send a letter saying, my case has been pending since. What is the status? If it's at the board, you should do the same thing.
Okay, this next question says, just wondering, this is from LSB, just wondering how well versed you are concerning the Camp Lejeune contaminated water. Okay, I'll answer that one. If you have one of the presumed conditions, we're as well versed as anybody else. I mean, it's you just look at the diagnosis and look in the service records to see whether or not there was service at Camp Lejeune. The important question, though, is just like with Agent Orange, and we talked about bladder cancer earlier, is where are the edges? Where are the frontiers? Where can we get good medical evidence for other conditions about what's happened with the Camp Lejeune water and the tetrachloroethylene that's in that water? And so what we do is we go through that C file, and we go through those service records, and we figure out how long you were there, and we'll go to our experts and talk to them about, here's what this man has, or woman has, and this is what they say, and they'll give us a kind of a curbside opinion as to whether or not that's a case we can make. And it depends on a lot of things. It depends on where you were at Camp Lejeune. It depends on how long you were at Camp Lejeune. Because remember, if it's a presumed condition, all you had to be is there was 30 days and you get the presumption.
Right.
But if you're looking for direct service connection based on an expert's testimony, then you got to show I was there a relatively long time. I was relatively close to where the contamination was. And so those are all factors that, again, when we go through that claims file, we sit down with you, we're looking to see what can we do? What can we do to put this together?
Camp Lejeune is just like Vietnam was. Vietnam, they had diabetes and a few others that they initially service connected. And then the list has grown and grown and grown. But for years, we had to get an expert saying, yes, bladder cancer is service connected. Yes, these other things are. An example of one that we've been fighting for years is hypertension. The medical records that the VA has done show that it is more likely that you have hypertension as a result of exposure to Agent Orange than a lot of the ones they've accepted, but they still haven't accepted it. So Camp Lejeune is going to be another one of those where there are myriad of conditions that have been caused by this exposure, but they're not being accepted yet. So you need to look at the research and see if they're saying, yes, it's pretty likely that this condition has been caused by this exposure, and then you're going to need an expert, because right now it's not service connected, but that doesn't mean you can't get it service connected.
Okay, James is following up with this question about service connection and existed prior to service, and he says that my diagnosis was 3 months after my ETS from active duty. James, I think you're getting a little bit deep on this. I think that we can't give legal advice over this.
Specifically.
Yeah. So all I can say is you probably need to talk to somebody about this.
It looks like you have a great claim, but you have to go through the file and see all of the facts, all of the evidence. But from what you're telling me, it looks great, but until you really look at it, you don't know. But I would pursue it.
Okay, now we got a question from Shemp Howard.
I can't see it.
Any advice for filing a cervical radiculopathy secondary to an already connected service string? Go for it.
Oh, yeah.
That's a good claim. That's a great claim. That's a claim where they're required. If you've got a doctor saying you've got cervical radiculopathy and they don't rate that when they rate the neck, that's clear,
a complication.
That's
so
clear
you get
unmistakable error.
You get the effective date back to when that was in the record.
This is Roger. So what can you tell us about the hugely unjust waiting period after filing? I've been waiting for over 2 years.
We've been doing this for 30 years and nothing has changed.
We're grinding our teeth.
We'll have people that are dying and we're begging them to act on it and they do nothing. And then we have people that, they can wait and it's decided right away. There is no rhyme or reason. It used to be that all the cases were decided where you lived. Now they have a national network, so they're throwing cases all over. There's no real person in charge, it seems like.
Okay, here's one from Blackwood Shark. VA has taken away my dependent, off my award because he receives DEA, yet lives with me, and I support all of his needs while he is in school full time.
Yeah, okay, so if this is what I understand, you are permanently and totally disabled, I would assume, so that he is getting his educational benefits after age 18. And therefore, those benefits go directly to him. I think that's what you're saying. And that means that you don't get benefits for him. That's the way that it works, if that's what your question is.
Okay, now here's another question that I think Matt has covered, but I'm going to answer it, and we're getting I'm being told we're getting kind of close to the end. But this is the question from Blackwood Shark. VA has taken my. Oh, no, I'm sorry, Blackwood Shark. This is from Robert Salazar. I need to file an additional claim. I am 90% for diabetes type 60. Okay, 60 gives the ratings. I had injuries to my neck, backs, and knees. Can I now file for those? The answer is yes on that. I don't know whether you filed for TDIU, but if you're not working, you sure should have done that. But again, this question may be getting a little bit deep into the.
And once again, you're asking about diabetes. Have you gotten all of the complications that go with diabetes awarded, so that maybe can up it with an earlier effective date? Whatever you file now, the effective date, if it's a new claim and it's unrelated, like back and knees, it would appear to be to diabetes or PTSD, then the effective date is going to be in the future, the month after you file. So if you want to get an earlier effective date for this high rating, I'd look for a complication as well.
Okay, George, you get a follow up to us saying that the VA continues this. Let's just go back and look at George's question real quickly here. I suffered a back injury while in service and went to ask a sick call and told them I had a pre-existing condition. Okay, and now they continue to deny your claim. Look, I have been told this kind of off the record time and time again. There are some cases that the regional office says, I'm not going to grant that unless the BVA tells me I have to.
Yep. I
don't care what the law is. We're just not going to grant it. And this is the kind of case.
Yep.
Okay, this is the kind of case where that happens, because if you file this claim before, it's likely that this claim is going to be reopened all the way back. And so the regional office is going to continue to deny this until you take it to the board, and the board will follow the law. I'll tell you what I tell my vets. The regional office is directed by the central office in Washington. They decide what they think the law is.
They don't follow the law.
The Board of Veterans' Appeals has to follow the law as given by the Court of Veterans' Appeals. And the Court of Veterans' Appeals is interpreting this as a veteran-friendly law in a way that is totally different from the way the central office does. So go to the board.
As long as you stay in the regional office, you're not going to win unless something extraordinary happens.
Okay. It's that time. How do I prove? That's the name. It's that time. Okay. How do I prove my aggravated flat foot with plantar fasciitis? They denied service connection after the C&P exam says aggravated by service, telling the VA and treating VA physician says aggravated by service. That's a case that if you've tried at the regional office and they say no, you need to go to the board.
Yeah.
But again, you're getting deep in the woods as far as your personal claim is concerned, and we need to stay away from that. But that's my gut reaction. Hey Carol, I have two questions. One for the VA and the other about medical discharge. Okay, and then the warrior. Let's see if we can find out. How safe is 100% P&T rating? Boy, I just want to answer the P&T part.
Go ahead.
Most of my veterans call me up and say, hey, I'm in Fat City. I got a P&T rating.
Permanent and total.
And I keep saying to them, that doesn't mean what it sounds like. Okay. Until your rating has been in effect for 20 years, the VA can take it away.
It's unlikely.
But what P&T means is they're not going to schedule a regular review exam for you. That's all it means. And if they, for instance, if you got 100% rating, in one of my cases, my vet had 100% rating for paraplegia. Neighbor next door saw him outside playing football with his son. Called the VA. The VA sent an investigator out. Next thing you know, he's got his rating taken away. So,
Yeah.
so P&T is not, P&T is not good. You have to have common sense. You shouldn't be telling anybody about what you're getting from the VA. It's none of their business. And you should act as if the VA's got eyes out there.
Remember,
and let me finish. And you should continue going to your doctor and
Exactly.
getting favorable medical reports.
so if you're service connected for something for 10 years, they can't take that away unless they can show fraud. But they can take the rating away unless you've been service connected for that rating for 20 years. Unless you can show fraud, they can show fraud. So basically, permanent and total is something they usually don't. Yes, probably you'll never see them again, but don't push it, because there are ways, like Ryan just said, that can happen.
Okay, let's do the warrior's second question to you, Carol, and then we've got to end. So his second question is: do you guys do discharge upgrades from medical discharge to medical retirement?
No.
Yeah,
we don't know anybody who does.
Well,
either.
But the bottom line, you're talking about cases that are involved in a completely different agency, the Department of Defense, and so we don't get involved in that. We don't know those regulations. Our focus is on the regulations from the VA administration, and that's it. That's as much as we can do today. Hopefully, our son Matthew will be back to talk to you again next week.
Have a good week.
Thanks so much for joining us.
Bye.
Bye.